Welcome to our deep dive today. I think you're going to find this really interesting. It's all about how India's patent system works. And today, we're going way back in time to explore its foundation. You could say like the origin story, the 1959 Ayyangar Committee report.
Oh, yeah. This report's a big deal.
Yeah, it is. It's a bit of a dense read, I'll be honest.
Mm-hmm.
But trust me, it's packed with amazing insights that really shape India's whole approach to patents and innovation.
Absolutely. This isn't just some dusty old document. It's like a roadmap for how India wanted its patent laws to work, especially in those crucial years just after independence.
Right, exactly.
Mm.
So we'll be going chapter by chapter, kind of unearthing some surprising facts
Yeah.
and analyzing, why this report is still so relevant. Even today, you'll see how India navigated international patent agreements, the role of public corporations in driving innovation,
Yeah.
and we'll even get into some fascinating patent law history.
That's going to be a fun ride.
It is. So let's jump right in. We'll start by unpacking one of the most fundamental concepts in patent law, anticipation.
Yes.
The report tackles this head on.
It does. It's all about figuring out if an invention is actually new, like truly groundbreaking. And here's the thing. Back then, India's laws only looked at public knowledge within India when deciding if something was really a new invention.
Wait, so something could be considered new in India, even if it was already known in other countries?
That's right.
That seems kind of unfair to Indian inventors, doesn't it?
That's exactly the question the report raises. It argues that this limited view of anticipation could actually hold back innovation and put Indian industries at a disadvantage globally. They really pushed for expanding the scope of anticipation to include knowledge published anywhere in the world.
Yeah, to make it a level playing field for everyone.
Exactly.
That makes a lot of sense. If you're competing on a global stage, you need to be aware of what's happening globally.
100%. And the report goes even further. It doesn't just talk about fairness for individual inventors, it highlights how this could impact entire industries, suggesting that a narrow view of anticipation could stifle growth and make it harder for India to compete on that global scale.
It's so interesting how this report connects these kind of technical legal details to the bigger picture of India's economic goals.
It's all connected.
Okay, now get ready for this. The chapter on chemical inventions reveals something pretty surprising. Apparently back then, chemical products themselves weren't even patentable in India.
Really?
Only the processes for making them were.
Interesting.
Can you imagine that?
It does seem a bit unusual from our perspective today, but there was a reason behind it. The report actually compares this to Germany's patent laws at the time, which also focused on process patents for chemical inventions, especially thinking back to the 1931 Depression.
So context is everything. It's
Exactly.
like trying to understand a painting without knowing anything about the artist or the time period it was created.
Perfect analogy.
Oh.
And thinking about how this historical context connects to today, it makes you wonder how these early debates shaped India's pharmaceutical industry as we know it, like in terms of generic drugs and access to medicine.
Yeah, it really does. It's like we're tracing the roots of a tree to see how it grew into the shape it is today.
Exactly. Let's move on to the report's examination of patent systems around the world. What stands out here is the variety of approaches different countries were taking, like the examination system in the UK versus the deposit system used in other places.
Right, and there's this intriguing detail about the U.S. patent law back then. There wasn't an opposition procedure.
You're right, the report points that out, and it actually caused some problems, because potentially flawed patents could slip through. There was no way to challenge an application before it was granted.
Oh, wow. That seems like it could lead to some serious issues.
Definitely. The report argues that opposition proceedings are super important. They're like a safeguard for the public interest. They make sure that the patents being granted are truly deserving of that protection.
Makes sense, like a system of checks and balances to make sure the patent system is working as intended.
Precisely.
And, this report isn't just about legal technicalities. It's deeply concerned with how patent laws actually affect people's lives and the economy.
Yeah.
It even goes into the complexities of patents related to defense.
Oh, yes. The issue of secrecy.
Exactly. That whole balancing act between national security and the transparency that's so essential to the patent system.
The report compares how different countries handle sensitive inventions. Like in India, the UK, other nations. It's fascinating.
It is.
Yeah.
It really is. Now, what about this register of patent agents?
Yeah.
Who were these people and what do they do?
Think of them as the guardians of the patent system.
Okay.
The report dedicates a whole section to discussing who could be a patent agent, what qualifications they needed, the responsibilities they held.
So you couldn't just have anyone helping someone file for a patent.
Oh, no. They had to have both scientific or technical knowledge, and legal expertise. It was a serious business. The report even suggests that companies and firms should be able to register as patent agents.
Wow, they were really making sure that the people navigating this system had the right skills to do it effectively.
Absolutely.
Okay, so now let's get to the heart of the report, the analysis of the specific clauses of the 1953 Patents Bill.
This is where it gets down to the nitty-gritty. The report breaks down each clause, from what can be patented to all these little details about patent of addition.
Patent of addition.
It's a way to protect improvements or modifications to an existing invention.
Ah, I see.
And remember our discussion about anticipation.
Yeah.
Well, the report examines the specific clause in the bill that defines invention and highlights how important it is to be clear about the impact of prior publications.
So they were connecting the theoretical concepts with the practical application of the law.
Precisely. And this meticulous analysis goes on and on. It covers everything, from the date a patent starts and the rights it gives you to the ins and outs of how a patent can be revoked.
Wow, thorough.
Very thorough. What about the administrative side of things? Did you notice how the report talks about the Patent Office and the Controller of Patents?
Oh yeah, they did. They went into detail about the structure of the Patent Office
Yeah.
and recommended setting up branches to handle the increasing number of applications. They also outlined the qualifications and responsibilities of the controller. You know, the person in charge of examining applications and deciding what's patentable.
It's a big job. The controller was essentially the judge.
Exactly. Making sure that only truly inventive creations get that legal protection.
Right. And the report emphasizes that the controller needs both legal and technical expertise.
Which makes sense.
Yeah.
You wouldn't want someone who only understands the law, but not the science behind the inventions, making those decisions.
Exactly. It's like saying you can't have a food critic who's never actually tasted the food.
Right. Uh-huh. That's a good one.
The report also talks about amending patent applications.
Amending.
Yeah. Making changes if needed, recognizing that sometimes it takes a few tries to get it just right.
So it wasn't a one-and-done situation.
Not always. The report outlines the procedures for making amendments and stresses the importance of being clear and precise in the language used. It also discusses the timelines involved and when the controller might ask for clarification or adjustments from the applicant.
It's not just about having a great invention. It's also about making sure the paperwork reflects that invention accurately.
Exactly. Clear and accurate documentation is essential for a strong patent system.
It's amazing to see how much thought and effort went into creating a system that balances the needs of inventors with the needs of society as a whole.
It's a complex dance.
It really is.
Now let's dive into something really important. The whole question of foreign applications. The report looks at this in the context of priority, right? It's a concept that comes from international agreements.
Priority, right. Okay, I'm not familiar with that. What does it mean?
So basically, it lets an inventor who's filed a patent in one country claim priority when they file in other countries. As long as they do it within a certain time frame, it's like a safeguard.
A safeguard. How so?
Well, it prevents someone else from stealing their idea and filing a patent for it in another country during that period.
Ah, okay. So let's say an Indian inventor files a patent in India first. Then they could file in the US or Europe, and their invention would be protected while those applications are being processed.
Exactly. That's the idea. And the report points out that back then, Indian inventors were kind of at a disadvantage because India wasn't part of these international agreements.
Oh, interesting.
Yeah. So they recommended that India think about joining these agreements. So Indian innovators could have the same protections as everyone else.
That makes sense. It's like making sure everyone has access to the same tools and resources.
Right, leveling the playing field.
Now, the report also goes into detail about the specific steps for securing a patent. It's not just about applying and getting approved. There's a whole process for requesting the sealing of a patent.
Oh, yes, the sealing. That's an important step. The report outlines all the requirements, the timelines, the fees, the documents you need. It even talks about what happens if the inventor passes away before the sealing is complete.
Wow, they really thought of everything.
They did. They were determined to create a system that was truly comprehensive and robust. No loose ends.
It shows how committed they were to building a system that was transparent and efficient, one that really worked for everyone involved.
Absolutely.
Yeah.
Now, you might find this interesting. The report also mentions amending a patent that's already been granted.
Really? I thought once a patent was granted, that was it final, like set in stone?
You'd think so, right? But there are actually times when changes to a granted patent might be considered.
So it's not always a done deal.
Not always. The report emphasizes that there needs to be a balance. They acknowledge that sometimes there are legitimate reasons to make changes to a patent after it's been granted.
Okay, I can see that. But wouldn't that cause problems for people who've already made decisions based on the original patent?
That's a valid concern. And the report addresses that too. It stresses how important it is to protect the rights of those who've relied on the original patent while also allowing for necessary amendments.
Right. So it's like saying you can renovate your house, but you have to be mindful of the impact on your neighbors.
Exactly. A great analogy. The report also talks about surrendering a patent, which means the patent holder chooses to give up their exclusive rights.
Wait, why would anyone do that? Giving up something so valuable?
Well, there could be different reasons. Maybe the invention isn't as profitable as they thought, or maybe the inventor has personal or ethical reasons for not wanting to enforce those rights anymore.
So it's like deciding to sell your car
Mm-hmm.
because you realize you don't need it or use it anymore.
Precisely. And the report lays out clear procedures for doing this, for surrendering a patent, to make sure it's fair and transparent for everyone involved.
It's incredible how much detail they put into every aspect of this. It's like they were building a house and thought about every brick, every nail, every detail.
They wanted a solid foundation. Now let's talk about the less pleasant side of things, revocation.
Revocation.
Yeah, when a patent is taken away, there are several reasons why this might happen.
Like what? What would cause a patent to be revoked?
Well, one reason is if the invention was already covered by a valid patent with an earlier priority date. Basically, someone else already had a patent for the same thing.
So no double dipping on patents.
Nope. Another reason is if the patent was granted to the wrong person.
The wrong person.
Yeah, like if they weren't actually the inventor, or if they got the invention through dishonest means.
Like getting your driver's license even though you failed the test.
Exactly. The report really emphasizes that patents should only go to those who truly deserve them, those who made a real contribution.
It's about upholding the integrity of the whole system.
Right, absolutely. And speaking of integrity, the report also talks about non-working patents as grounds for revocation.
Non-working patents, what's that all about?
It means the patent holder isn't actually using the invention to make a product or offer a service in India. They're sitting on it.
So you can't just get a patent and then do nothing with it.
That's the idea. The report says that goes against the whole purpose of patents, which is to encourage innovation and economic activity.
It's like having a car but never driving it.
Right, exactly. What's the point? The report even suggests that the law should be stronger on this, to make sure that patents are revoked if they're not being used.
All about making sure the system is actually benefiting society.
100%. Now, I know you're probably curious about compulsory licensing.
Compulsory licensing. Yeah, I've heard that term before, but I'm not really sure what it means.
It's a way to prevent people from abusing their patent rights. It allows someone else to use a patented invention, even without the patent holder's permission, under certain conditions, of course.
So it's like being allowed to borrow someone's car, even if they don't want to lend it, as long as you follow certain rules.
Good analogy. The report talks about several reasons why a compulsory license might be granted. For example, if the patent holder isn't meeting the needs of the public.
Like if they're not making enough of the product, or if they're charging way too much.
Exactly. It's a way to stop them from just hoarding their invention and making huge profits, while people can't access something they need.
It's about finding that balance again,
Right.
between rewarding inventors and making sure that their inventions benefit everyone.
Precisely. Another reason for a compulsory license might be if the patent holder refuses to let others use the invention, even if they offer fair terms.
So they're stifling competition.
Right. It's like having a toll road and refusing to let anyone use it, unless they pay an outrageous fee.
That makes sense. So compulsory licensing is like a way to make sure patents are used fairly and for the greater good.
That's the idea. The report argues that it's essential for preventing abuse and making sure that patents truly benefit society as a whole.
Okay, now what about these licenses of right? That sounds almost like a legal loophole or something.
Not exactly. Licenses of right are actually designed to encourage wider use of inventions.
How so?
If a patent is endorsed with licenses of right, it means anyone can apply for a license to use that invention.
So it's like opening up that toll road to anyone who's willing to pay a reasonable price.
Exactly. The report talks about how this can boost competition. and make inventions more accessible, especially in fields like pharmaceuticals, where it's really important for people to have access to the latest treatments.
Right, so essential inventions don't become monopolies that only benefit a select few.
Exactly. It's about ensuring that everyone benefits from innovation.
It's like a safety valve for the whole system, making sure things run smoothly.
Great way to put it. Now let's shift gears a bit and talk about government use of patents.
Government use of patents. Does that mean the government can just take any invention they want?
Not quite. The report outlines specific situations where the government can use patented inventions. It compares it to the UK's concept of service of the crown, which allows the government to use inventions for public purposes.
So things like national defense or public services.
Exactly. It's not about the government taking ownership of the invention. It's about making sure they can use it for the public good.
Right. So it's a delicate balance between protecting the rights of inventors and ensuring that the government can access important technologies when they need them.
Exactly. The report really stresses the need for clear legal frameworks to handle these situations, so everything is fair and transparent.
It's like walking a tightrope between private property rights and the public interest.
That's a great way to put it. Now let's move on to something a bit different: restrictive trade practices.
Restrictive trade practices. I'm not sure I've heard that term before. What does it mean?
It's basically when companies do things to manipulate prices, limit production, or push competitors out of the market.
Okay. So even if they have a patent, they can't just use it to bully other companies or control the market.
That's right. The report compares India's situation to laws in other countries like Canada, France, Sweden, the UK. They all have ways to prevent these practices. And the report suggests that India should consider similar measures.
So it's like having a referee in a game
Hmm.
to make sure everyone's playing fair.
Precisely. The report argues that a strong patent system needs these safeguards to prevent abuse and protect consumers.
This is fascinating. It's like getting a behind-the-scenes look at how patent laws are made. It's not just about the inventors, it's about the economy and society as a whole.
It's all connected. And as we continue exploring this report, we'll uncover even more insights into this intricate world of patent law and its impact on India's development.
So we've covered a ton of ground already.
Oh,
But there's this one more really important piece of the Ayyangar committee report I want to dig into, the opposition process.
oh yeah, that's a key part. It's basically a way for anyone to challenge a patent application before it gets granted.
So like if someone thinks the invention isn't really new,
Hmm?
or that it doesn't deserve a patent,
Exactly. The report makes a strong case for how valuable this process is. It ensures that patents are only awarded for truly innovative ideas, not just anything someone throws together.
makes sense. It's sort of like a peer review system for inventions.
That's a great way to think about it. And the report actually recommends making the opposition process even stronger in India, giving people more ways to object, so the system is even more robust.
Interesting. Now, switching gears a bit, the report also delves into patents related to defense,
Hmm.
where secrecy is really important. How do you balance that need for secrecy with the whole idea of transparency in the patent system?
Yeah, that's a tough one. It's a real balancing act. The report looks at different approaches. Like in the UK, they have these secret patents where the details are kept hidden from the public. India at the time relied on the Defense of India rules to protect sensitive inventions.
So it's like having a secret vault for certain patents.
Exactly. And the report stresses the need for clear laws in these situations, to make sure we're protecting national security,
Yeah,
but without completely sacrificing transparency and accountability.
right. It's a delicate balance. Now, speaking of balance, I'm always interested in efficiency. Did the report have any suggestions for making the patent office run more smoothly?
Oh, yeah. It went into detail about the administrative structure and pointed out areas for improvement, like streamlining procedures, adopting new technologies, and hiring more staff to handle the increasing workload. They even suggested setting up branches of the patent office in different parts of the country to make it easier for inventors to access.
So it's all about making the system more user-friendly, less bureaucratic.
Precisely. They knew that delays and red tape could discourage inventors, and that would slow down progress. It's like having a well-maintained highway system. It keeps things moving smoothly.
Love that analogy. Makes perfect sense. Now, I know this can be a bit dry, but the report also talks about legal proceedings related to patents, which sounds kind of intimidating, to be honest.
I know what you mean. It can be a bit much, but it's important stuff. We're talking about lawsuits for infringement, petitions to revoke patents, appeals against decisions made by the controller, all that legal stuff.
Right. So if there's a dispute over a patent,
Yeah.
this is where it gets settled.
Exactly. And the report suggests setting up special patent courts with judges who really understand both the law and the technology involved.
Makes sense. It's like having a team of expert mechanics to fix your car. You wouldn't want just anyone tinkering under the hood.
Right. Especially when you're dealing with something as complex as a patent dispute, you need people who know what they're doing.
Yeah.
So the report really pushes for a strong legal system that can handle these cases fairly and efficiently.
This has been an incredible journey, exploring this landmark report. It's amazing to see how much thought went into creating India's patent system.
It really is. The Ayyangar Committee report is a testament to the vision of those who shaped India's approach to innovation. They understood how crucial it was to balance the rights of inventors with the needs of society.
And it's a reminder that patent systems are always evolving. They have to adapt to the changing world. Who knows? Maybe someday you'll be part of shaping these laws to make sure they continue to promote progress and prosperity.
Now that's an inspiring thought.
It has been a true deep dive into the foundations of India's patent system. Thanks for joining us.